Next, from Springfield, we talked to attorney Esther Seitz about the application of the Freedom of Information Act regarding new technology and public officials. In light of the recent scandals involving the former chancellor of the University of Illinois and Democratic presidential candidate Hillary Clinton, this runs about 15 minutes.
Esther Seitz, thanks for joining us on the Illinois Channel. And we wanted to talk to you, being an expert in FOIA, the Freedom of Information Act, as it pertains to government. We've had a number of examples recently. People will be aware of Hillary Clinton and what's going on with her emails. We've also had an example with the university chancellor at the University of Illinois using private emails, and there have been other cases. So we wanted to get a handle on, as we have these new technologies, or not, maybe not even so new anymore, but we have emails, we have phones, smartphones, just how the Freedom of Information Act should still be applied when it comes to people in government discussing public policy issues. Can you give us an overview of the law?
Sure. One thing that has become popular among public officials is the use of private electronic devices to conduct public business. Now, previously, those types of transactions were done by public officials on their public letterhead and or on their public email, and now everybody uses their smartphone. We do so much business on our handheld devices, and a lot of public officials, too, are using their private iPhones to write emails concerning government business to other public officials or even just to constituents. And the point where this becomes a problem FOIA-wise or public access-wise is that when somebody, a citizen requester, makes a request for an email that, for example, Hillary Clinton sent concerning State Department business, it's hard for the agency, the government body, to get a hold of that email because it's not within the records that they're generally searching, the records that are on their server. And there have been a number of public bodies, the State Department one, but also the governor's office and the University of Illinois here in Illinois, that denied records requests for emails that were sent on private devices because they claimed they didn't have access to the emails, or because they said it's not our job to go get the emails from a private email account or a private that was stored on a private cell phone because they're not government accounts or government issued devices. That's legally incorrect, however, because the FOIA says that what matters is the content. So what matters is not the location of the communication, here the email, but rather what matters is what is the email about. And if the email is about public business and it is being used by a public official in the public official's public functions, or while the public official is performing her public duties, then it is subject to FOIA. So it really doesn't matter whether or not it is located on a private or a government-issued device or account.
When we have government entities discussing public business, how long under FOIA are they supposed to keep these records stored? Or is there a period of time at which they can erase them and get rid of them?
So FOIA generally does not regulate that. FOIA is a statute that compels government to turn over public records when they're being requested. The Local Records Act and the State Records Act governs the retention of public records. So that's actually legally a little bit of a different issue, but you raise a good point because if the information is stored on a private phone, then the settings aren't the same as the government's document retention policies. So for example, let's say for a certain type of police record, it might be 10 years. If that same record is stored on a private device or private account, what prevents the owner of the account from deleting it? Of course, it would be a violation of the FOIA because it's a public record and you shouldn't be deleting public record. But it's hard for the government agency to monitor their officials or their independent contractors when they're really just using their private devices. And they may not be knowingly violating the law.
Well, I don't want to make this about Hillary Clinton per se, but let's use that as an example. Here she has gone through the effort of setting up her own server in her own domicile, as I understand it, and then deleted when the Congress was asking for some of those documents, deleted it. So if a person, whether it's Hillary Clinton or if it's an alderman at a city, if I'm an alderman at a city using my own cell phone to be texting another alderman or the mayor, can I go ahead and delete those emails off my phone so that then they're no longer available, or would I then be in violation of the law?
I think you would be in violation of the law because it's a record concerning public business and it's being used and sent by a public official. And because of that, it really belongs to the government. It belongs to the people. And if a citizen requester or a media requester looks for it, by way of the FOIA, then it should be turned over. But I think that public officials are often under the misimpression that it's my phone, it's my email account, I can delete whatever I want. So it probably gives them a sense of ownership and security that is misplaced.
Does it matter at all if I'm using let's say I'm an alderman, if I'm using a city telephone, a phone owned by the city as compared to my own phone, and let's say I was discussing a romantic date coming up with a private individual that had nothing to do with the public's business, would people still have the right to ask me for those emails, or what carve-outs are there for privacy rights of a public official?
Good question. And that situation or issue was actually adjudicated by the court in the Madigan versus City of Champaign case. And the court said what matters is that it's about public business. So if it's an email from a council member, like you said, texting another council member during city council meeting about a dentist appointment, about a romantic date, it's not a public record because it doesn't concern public business and it does not concern the performance of the public function. However, when the email or the message concerns the transaction of public business, that's what triggers FOIA. That's what I meant when I said it's content that matters, the content relating to public business as opposed to the mere location of the communication.
Can anyone, I think some people are under the impression you have to be a reporter to request a Freedom of Information Act. Can anyone request a Freedom of Information Act from a public official?
Yes, that's right. The Illinois FOIA applies to anybody who files a request, any person who files a request. You do not have to be a member of the media.
And under the Illinois law, how long should it take for the public official to supply the data that's being requested?
5 days, and that's business days. The public body can, for a number of reasons, request an extension, but the regular time is 5 days.
Has the law proved workable in your estimation, or does it become onerous and make it, if everyone's requesting information, it would seem the public officials would be doing nothing but handing out data rather than doing their jobs?
And I think that some public bodies claim that they are burdened with FOIA requests. I think generally that's not a problem. Even though all citizens have a right to request public information through the FOIA, I don't think we do. I think in the end it's really being a tool that is being used mostly by the media and then by some citizens who are particularly involved in government. But I do think the law is working. I don't think it's working perfectly. I think it has its problems. I think the private email conundrum is one of them. I think that will work itself out. But really the law as it currently stands, it already addresses the issue, and I think it addresses it clearly that even though a public official is doing public business on her private iPhone, that message, that text message, email, whatever it is, it's still subject to the FOIA, and it's still a public good that the public has a right to see.
A couple more questions. What are the punishments? How do we enforce it? If a public official says, or a public entity, a city government says, no, we're not going to give you the documents, what recourse is there for the person requesting the information?
The person can go, two options really. The person can go to the Illinois Attorney General's office. The office has a division for public access cases like that. It's an informal process by which the Attorney General's office resolves disputes that are arising under the Illinois Freedom of Information Act. That process, it's open to anybody. And the other avenue is filing suit. So if a requester is denied access to public records, that notice of denial, the letter from the government that says we're not going to turn the records over for XYZ reason, that is a ticket to court. So based on that notice of denial, anybody has the right to file a civil lawsuit here in circuit court and demand that the public body turn it over. Of course, you have to persuade the judge that the requester has a right to the records, but the default rule under the FOIA is that the citizens have a right to see public records. There's a number of exemptions to that general rule, but the presumption is one of access.
And that was going to be my next question. What are the legitimate exemptions from handing over information?
They are all listed in Section 7 of the statute. I think there's a number, it's over 20 exemptions. One of them is for personal privacy reasons. So for example, text message that would discuss a romantic date or a medical appointment, that would fall under the personal privacy exemption. There's an exemption for certain type of law enforcement records. For example, if a record, the disclosure of which would impede somebody's right to a fair trial, that type of record would also be exempt. But there's a list of exemptions, and they're certainly available, and they do get invoked.
Now, if it's invoked, who decides that that's a legitimate exemption as compared to someone just wanting to cover up malfeasance by saying that's a medical record that really wasn't a public record?
That's what will get resolved by the judge. So if you pursue the judicial avenue, the judge resolves that question. It's a legal issue for the judge to resolve. Or if a citizen requester takes it to the Attorney General's Public Access Bureau, the Public Access Counselor's office resolves that question. But that's what it often boils down to in FOIA cases. Does the general rule of access apply, or does one of the exceptions to the general rule apply that provides privacy for certain type of records?
And when we talk about the Freedom of Information Act, and we talked about the Illinois law, is the law the same across the country, or does it vary by state?
Every state, I believe every state has its own public records law. In Illinois, it's called the FOIA, and some it's called Public Records Act. They vary from state to state, but the general point of those laws is to provide citizens access to public records so that the citizens can see how efficiently and effectively government is working. The federal government also has a FOIA, and that FOIA applies to all the U.S. agencies.
We have state lawmakers. Some of them are full-time lawmakers. Others do business on the side. Some of those are lawyers. And if someone said, hey, I want to have a list of your clients as an attorney to see if possibly there's some collusion going on relative to the bills you're proposing. Can you go on a fishing expedition, or do you have to really define what you're looking for when you put in a FOIA request?
I mean, generally, I think it's good to be specific when one files a FOIA request. I think that helps the public body locate the documents. In the hypothetical that you present, I think it might be difficult to get the list of clients because it really doesn't relate to the performance of a public function.
Well, it may, but we don't know that, right?
Yeah, but if you're looking for the client list of the firm, I think that would be a tough sell. And I'm generally pro-access, but the relationship that a lawyer has with the client is protected by the attorney-client privilege, and if the client would want the fact that the relationship exists, if the client wants that to remain confidential, then I think there's a possibility that type of information would not have to be released under the FOIA. Of course, it's different if it's a government contractor. If it is a business or a client of the government, somebody that is using government resources or being employed by the government, then that type of client list would be subject to disclosure.
So even if it's a private company, but if, let's say, they're a defense contractor or they're selling a product or service to state government?
Absolutely.
You could?
Yes. As long as you're doing business with the government in order to help the government perform a government function, it's subject to FOIA. I think it's different when a public official has a side business as a lawyer, and that law firm, that private firm, has a client list.
And finally, if people would want to have more information, is there a website or some source where they could learn more?
Yes, I think the Illinois Attorney General's office has a good website on the Illinois FOIA and the Open Meetings Act, and it is operated by their Public Access Bureau, provides some information, general oversight information.
Okay, great. Esther Seitz, thanks so much.
Thank you.